The recent Nagpur bench of Bombay High Court judgment has drawn the attention of Indian legal community. Satish, a resident of Nagpur, has been accused of abducting a girl, molesting and possible sexual assault on a minor girl who is of age 12. Satish was primarily charged with the act of pressing the child's breast and exposing her private parts. In February 2020, Child Court in Nagpur found Satish guilty under Section 354 of the Indian Penal Code, which states any act of criminal force committed on a woman to outrage her modesty, and Section 363 of IPC kidnapping, and Section 343 of IPC wrongful confinement, and most importantly Section 7 and 8 of POCSOACT 2012. Satish was sentenced for 3 years with a fine of ₹500. Later, Satish filed an appeal in the Nagpur bench of Bombay High Court challenging the verdict of Child Court. While replying to Satish's appeal, the Bombay High Court said that it is considering whether the pressing of breast and attempt to remove salwar would amount to the definition of sexual assault as defined under Section 7 and punishable under Section 8 of the POCSO Act. In the process of delivering a verdict, Justice Pushpa Ganediwala had gone through definition of sexual assault in Section 7 and its punishment under Section 8 of POCSO Act 2012. Section 7 states that whoever with sexual intent touches the vagina, penis, anus, or the breast of the child, or makes the child touch the vagina, penis, anus, or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration is said to commit sexual assault. Section 8 deals with the punishment for sexual assault. That is, whoever commits sexual assault shall be punished with imprisonment of either description for a term which shall not be less than 3 years but which may extend to 5 years, and shall also be liable to fine. On the other hand, Section 354 IPC states any act of criminal force committed on a woman to outrage her modesty. Justice Pushpa compared POCSO with the Section 354 of the IPC to see if the accused can be convicted under both the laws as the Child Court had declared. To understand this, we need to understand these two laws and their differences. POCSO Act is set up as guilty until proven innocent setup rather than general innocent under proven guilty setup. So burden of proof is on accused, and this makes the offences more stringent than the IPC sections. Also, POCSO is gender neutral and Section 354 applies only to women. Punishment under POCSO is 3 to 5 years, whereas under Section 354 it is 1 to 3 years. Justice Pushpa had interpreted the Section 7 of POCSO Act at length and breadth and stressed that physical contact in Section 7 means accused having a skin-to-skin contact with the victim. Mere groping will not fall under the definition of sexual assault. Hence, the court held that touching a child over her clothes will not attract an offence under the POCSO Act. Court also opined that there should be stricter proof and serious allegations to sentence someone under the POCSO Act. At the same time, it held that it attracts an offence under Section 354 of the IPC as this incident outraged the victim's modesty and convicted Satish for a period of 1 year. The verdict is criticized for many reasons. Firstly, for example, if the offender is using a glove for touching the naked body of a child, then also the offence under the POCSO Act cannot come into operation because there is no skin-to-skin contact. Also, the fact in the case was the accused deliberately caught hold on the breast of a child of 12 years over the dress. The court convicted him under Section 354 IPC, which means that his intention was established. In other words, it was not an accidental or unintentional touch, but the fact that the offender cannot be tried under POCSO Act is bizarre. Moreover, POCSO provisions doesn't mention anything about skin-to-skin contact. Bombay High Court, in the process of the interpretation, brought something else which was not part of the provision. Experts also suggest that this judgment would send a wrong signal to the child courts and gives immunity to the habitual offenders. The National Commission for Protection of Child Rights had written to the Maharashtra government describing the judgment as absolutely unacceptable, outrageous, and obnoxious, and also asking it to review the clause in Section 7 of the POCSO Act. Attorney General K.K. Venugopal had filed a petition in Supreme Court challenging the Bombay High Court's verdict and also submitted that the judgment is likely to set a dangerous precedence. In response, Supreme Court stayed the order of the Bombay High Court on 27th January 2021. To conclude, in the factual circumstances of the case, the only possible conclusion can be that the offender is liable to be punished under Section 8 of the POCSO Act 2012, which carries a minimum of 3 years, and not under Section 354 of IPC. While respecting the Indian legal system of procedure established by law, experts feel that there is a need for adapting the American system of due process of law, as the real essence, spirit, or the purpose of POCSO Act has been diluted or overlooked in this particular case. Thank you.